Welcome back to Law Simplified. In our previous masterclass, we looked at how the law protects the human body. Today, in Volume 3, we shift our focus to how the Kenyan justice system protects what you own. We are dividing deep into offences against property under the Penal Code, Cap 63, the laws of Kenya. People use the words theft, robbery, and burglary interchangeably in these streets. But in the courtroom, confusing these terms will cost you the case. Today, we are going to define the exact statutory differences, the specific actors and mens rea elements, the landmark Kenyan case laws, and the unique defenses that apply only to property crimes. Let's get to work. The first offense, theft, well known as stealing, and the claim of rights under Section 268. Under Section 268 of the Penal Code, stealing occurs when a person fraudulently and without claim of right takes anything capable of being stolen. The actus reus here is the physical taking and carrying away of property, which now is exportation. The property must actually be moved. The mens rea is the animus furandi, the intention to permanently deprive the owner of the property. Now let me give you the exam trap. Listen closely. Section 268 says without claim of right. Under Section 8 of the Penal Code, if you take someone's property because you honestly, genuinely believe that the property belongs to you, you are not guilty of theft. And if you believe is legally wrong, the fact that it is honest negates the mens rea, the fraudulent intent of depriving the owner of their right to claim the property. You cannot steal what you honestly believe is yours. Let me give you an example. If you take a classmate's or a workmate's laptop on the desk, thinking is the exact model you own and that you are just taking your own property home, that is a mistake of fact, leading to a claim of right. You lack the animus furandi, the intent. But if you realize it's not yours when you get home and decide to sell it anyway, then their theft occurs the moment you form the intent to take away the laptop from the owner. The penalty here is 3 years imprisonment, but it can increase to 14 years for stealing from an employer or stealing a motor vehicle. Now let's move on to part 2, robbery and aggravated robbery under section 295 and 296. So what happens when you add violence to theft? It evolves to robbery. Under section 295, robbery is stealing anything while using or threatening to use actual violence to obtain or retain the item. The actus rea here is the act of theft plus the use or threat of actual violence. The mens rea is the intent to steal plus the intent to use force or fear to accomplish the theft. The crucial link is the violence must be used in order to steal. If you get into a bar fight, knock someone out, and then notice their wallet on the floor and take it as an afterthought, that is assault and theft, not robbery. The violence did not facilitate the theft. Now let's move on to aggravated robbery, well known as robbery with violence, under section 296 2. So, to elevate this to robbery with violence, you must prove at least one of the aggravating factors as established in the landmark case of Munyao versus the Republic. One is the offender is armed with a dangerous or offensive weapon. 2, the offender is in the company of one or more persons. 3, the offender beats, strikes, or uses personal violence at the time of the robbery. So the penalty here for these two crimes is robbery with violence is a capital offense, historically punishable by death. Then we have the offense of housebreaking and burglary under section 304. So what is housebreaking? Housebreaking is breaking and entering a human dwelling with the intent to commit a felony. What is burglary? Burglary is the exact same offense but committed at night. The Penal Code strictly defines night as from 6:30 p.m. to 6:30 a.m. Now let's move on to the actus reus. The actus reus is the actual breaking, which can be just turning a closed door handle or using a copied key and entering the dwelling. The mens rea here is the intent to commit a felony therein. So let me give you a scenario. A suspect pushes open an unlocked kitchen window. If done at 2 p.m., that is housebreaking. And the punishment here is 7 years. If done at 10 p.m., it elevates to burglary, which the punishment is 10 years in prison. So, breaking in just to find a place to sleep is a civil trespass, not burglary, because the mens rea here is to commit a felony. And when you enter a human dwelling with the intent to just sleep there and in the morning and go, that's just trespass. Then let's go to obtaining by false pretense, well known as fraud, under section 313. So, what if someone tricks you into handing over your property willingly? Under section 313, this is obtaining by false pretense. The actus reus here is making a representation of a matter of fact that is false, which induces the victim to hand over the property. The mens rea is the specific intent to defraud someone. So let me give you a scenario. So to prove this, the lie must be about a present or past fact, as held in the case of R versus Dent. So if Brian says, lend me 50,000 and I will double it next year, and runs away, that's a broken promise about the future. But if he hands you a forged logbook today and says, I own this car, give me a deposit, he has committed the offense of fraud. Then let's go to criminal damage and arson, section 332 and section 339. So these are situations where the accused does not want to steal your property, they just want to destroy it. So let's go to the first one, criminal damage under section 339. Any person who willfully or and unlawfully destroys or damages any property is guilty of an offense of simple criminal damage. The actus rea here is the physical destruction of or damage of property. The mens rea here is doing it willfully, intentionally, or recklessly, and unlawfully without a lawful excuse as to why you are destroying the property. Then we have arson as per section 332. This is the most aggravated form of criminal damage. Under section 332, any person who willfully and unlawfully sets fire to any building, vessel, or agricultural crop is guilty of the offense of arson. Let me give you a teaching scenario. So, during a riot, a person throws a petrol bomb into a shop. The shop burns down. The charge here is arson. It carries a maximum penalty of life imprisonment because fire is inherently uncontrollable and endangers human life. So with that, I will sum it up to help you with the offenses against property. The first one, theft, taking property without consent, subject to the claim of right. Then we have robbery, stealing using force or threat of force. Yes, so you can also check out the main differences between the twin offenses of robbery and robbery with violence. Then we have burglary, breaking into a dwelling at night to commit a crime. Housebreaking was during the day. And you always remember that burglary occurs from 6:30 p.m. to 6:30 a.m. Then you have fraud, taking property without consent obtained through a lie about past or present fact. Then you have arson, where it discusses about willfully and unlawfully destroying property with fire. Then you have criminal damage for destroying property. So with that, we have tackled the offenses against property. Subscribe, share, like, and comment, and I will see you in the next one. And let's keep simplifying the law one case at a time. Thank you so much for listening.